All right, guys, this week you just have a assignment dealing with a discussion board. And what you have to do is after review the module resources, consider the following question. Do prisoners have too many or too few rights? And then explain your response. And as you explain your answer, consider the challenges the correctional system faces and or the challenges faced in prison life. And then you have to respond to two peers and state whether you agree or disagree with their opinion and why. So I just want to talk real quick about prisoner rights because I think it's important that you understand which constitutional rights over the decades have been applicable to those incarcerated. So just because you're in prison does not mean you lose all of your rights. You still are entitled to certain constitutional rights. And these have been outlined by the Supreme Court probably since the beginning of the 1960s when the courts began to take a no hands-off policy. They had a hands-off policy prior to the 1960s, and beginning in the 1960s, they started interpreting constitutional rights that are associated with prisoners. All right, so I'm going to try to make this in 15 minutes, so you'll have to bear with me, and then I'll post this power slide in its entirety without the narration in the announcement this week, because this came from a different textbook, but I think you'll find much of it applicable, and maybe the information will be useful to you. Okay, so constitutional rights of prisoners is outlined two ways, what we call the least restrictive method and the compelling state interest. So least restrictive method means it's a means of ensuring legitimate state interests such as security that impose fewer limits on prisoners' rights than do alternative means of securing that end. And then the compelling state interest is an interest of the state that must take precedence over rights guaranteed by the First Amendment. So the constitutional rights of prisoners, again, also we have the element of clear and present danger, basically any threat to security or to the safety of individuals that is so obvious and compelling that the need to counter it overrides the guarantees of the First Amendment. For example, inmates cannot receive certain written publications as they might be detrimental to the security of a prison or the efforts to rehabilitate the prisoner, meaning that the institution can control what an inmate receives in the mail, as long as it is demonstrated that it shows a clear and present danger to the institution or to the inmate in his rehabilitative efforts. Constitutional rights of prisoner, again, the rational basis test. So go ahead and read through this, but it requires that a regulation provide a reasonable, rational method of advancing a legitimate institutional goal. So again, there must be some legitimate reason, a rational basis for whatever rule that exists. And as some of you will recall in some of our previous assignments, we talked about Turner v. Safely, and that was the Missouri ban on correspondence between inmates at different institutions as a means of combating prison gangs and communicating escape plans. The court developed a Turner test, and some of you discussed that in one of your previous milestones where you had to select a case. Well, that was one of those cases. But again, it has to have a reasonable basis. These rules that institutions impose have to have a reasonable basis. And these are guidelines that have been established by the Supreme Court. So if we take a look at the First Amendment issue, and I will tell you that the applicable Bill of Rights that apply to prisoners are the First Amendment, the Fourth Amendment, the Eighth Amendment, and the 14th Amendment, okay? So the First Amendment primarily deals with speech in the form of mail, and this is the case of Turner versus Safely, and religion, Black Muslims and Fullwood versus Clemmer. And so you can see that the two areas that come up in institutions is the issue of speech and then, of course, the issue of religion. So, for example, in 1974, Supreme Court ruled that censorship of mail was permissible only when officials could demonstrate a compelling government interest and maintaining security. The decision in Turner versus Safely allowed Missouri to ban correspondence between inmates at different institutions as a means of combating prison gangs and communicating escape plans. The court reaffirmed this in 2001 when it said that regulations concerning mail among prisoners are valid if they meet the Turner test, without regard to whether the letters contain information relevant to a legal case. And so the Turner test is basically a multi-pronged test that institutions have to consider as they evaluate whether or not the rule or policy that they're putting in place is necessary. Regarding religion, the First Amendment prevents Congress from making laws respecting the establishment of religion or prohibiting its free exercise. Cases concerning the free exercise of religion have caused the judiciary some problems, especially when the practice in question may interfere with prison routine and the maintenance of order. In an early case, this is Fulwood versus Clemmer in 1962, a federal court ruled that officials must recognize the Black Muslims as a religion and allow them to hold worship services as inmates of other faiths do. It did not accept the view that the Muslims posed a clear and present danger. In another religion case of Cruz versus Beto in 1972, the justices declared that a Buddhist prisoner must be given reasonable opportunities to practice his faith like those given prisoners belonging to religions more commonly practiced in the United States. And then finally, in Olone versus the Estate of Shabbat in 1987, the court ruled that a Muslim's free exercise rights were not violated by prison officials who would not alter his work schedule so that he could attend Friday afternoon Jummah services. Shabaz's assignment took him outside the prison, and officials claimed that returning him for services would create a security risk. The justices ruled that the policy was related to a legitimate penological interest. So you can see here where the courts have been struggling with the issue of religion in the courts, or religion in prisons, and you know how far it is that organizations such as penal institutions can limit or control that activity. Next is the Fourth Amendment, and again, the Fourth Amendment is basically prohibits unreasonable searches and seizures, and so it was there are a couple key cases here I think that will help you out here in trying to determine whether or not the Fourth Amendment applies. One is Hudson v. Palmer in 1984. The Supreme Court made clear that the Fourth Amendment does not apply within the confines of the prison cell, and that searches of the person may be conducted at different levels of intrusiveness: metal detectors, pat-down searches of clothed inmates, visual strip, nude searches, and body cavity searches. Correctional administrators must craft regulations to demonstrate clearly that the level of intrusiveness is related to a legitimate institutional need and not conducted with the intent to humiliate or degrade the inmates. So, again, even though the Fourth Amendment really has limited applicability to inmates, because once in prison, most of these rights are forfeited, you need to understand that there are still certain requirements from the institution, especially if you're getting into areas of cavity searches and those type of intrusive searches. Again, the courts have said that they need to be done for legitimate institutional concern, and that they're not conducted with the intent to humiliate or degrade the particular inmate. Okay, so the Fourth Amendment, again, dealing with searches. In addition, we have Lansing v. New York in 1962. Basically, conversation recorded in jail or prison are not protected, so that institutions can listen to those, can monitor those. The only exception might be if it's an attorney-client type case. In Hudson v. Palmer, 1984, again, we already talked about that, but they can search cells without a warrant or probable cause or any reasonable suspicion. A lot of times random searches are done as a means to control the institution, safety, things such as that. Now, the Eighth Amendment, again, cruel and unusual punishment. Some prominent cases are Maurice versus Estelle, which is confinement conditions. Basically, in this case, it involved Texas, and The whole institution, the Texas Department of Corrections, came under scrutiny, and the courts looked at many facets of the Texas Department of Corrections and found some constitutional issues of violations that met the Eighth Amendment, cruel and unusual punishment. So again, there's three principal tests determining the unconstitutional conditions: whether the punishment shocks the conscience of a civilized society, whether the punishment is unnecessarily cruel, and whether the punishment goes beyond legitimate penal aims. And so the two cases here, Ruiz versus Stale, the second one is Rhodes versus Chapman, which is 1981. The courts ruled that double bunking is not necessarily a violation of the Eighth Amendment. So here you can see what constitutional rights they have regarding the Eighth Amendment, right? California came under some scrutiny a handful of years back regarding lack of proper medical care, and claims were brought under the Eighth Amendment. And the argument being that there were too many inmates within the California Department of Corrections to properly provide medical care. And so the federal courts came down hard on California, and basically they had to start releasing some inmates early. And they're still working through a lot of that in terms of inmates and which ones should be released. And so it just gives you an idea as to how the courts might apply the Eighth Amendment in terms of cruel and unusual punishment, and some of that has to do with overcrowding. Not necessarily the issue of overcrowding, but the issue of whether or not that overcrowding causes some other type of legal issues, such as lack of proper medical care, maybe security, things like that. And you can take a look at that. There's just totality of the conditions that the courts will look at, not just one specific element of an institution. And finally, the 14th Amendment. 14th Amendment has to do with procedural issues, which is no different than what you and I experience on the outside. The constitutional guarantee that no agent or instrumentality of the government will use any procedures other than those procedures prescribed by law to arrest, prosecute, try, or punish any person. Equal Protection Clause, constitutional guarantee that the law will be applied equally to all without regard for such individual characteristics as gender, race, and religion. And so this comes into play when inmates commit some type of violation as outlined in institutional guidelines. And basically what they're saying here is that just because you're in prison doesn't mean your due process goes out the window, and that there are minimum due process issues or rights that are guaranteed for disciplinary purposes. The prisoner must be given 24-hour written notice of the charges. The prisoner has the right to present witnesses and documentary evidence in defense of the charges against him or her. The prisoner has a right to a hearing before an impartial jury. In this case, it's a panel, not necessarily a jury. Usually they have a right to appeal to someone within the institution. There's no jury involved here. The prisoner has a right to receive a written statement from the body concerning the outcome of the hearing. So what happened on an appeal. So let's say, for example, I got caught smoking in a part of the institution where I'm not allowed to smoke, and a guard wrote me up for it, and let's say my punishment I thought was going to be rather severe. I could appeal that. There has to be a procedure. So it's much like I would expect in your job, especially working in the public sector. If you get charged with some infraction or something within your profession, you have a right to appeal that first initial decision by a supervisor to somebody within the organization to try to seek some other remedy. So this is really designed, this due process issue, the 14th Amendment, is really designed to keep cases out of court. Let the institution try to resolve those as quickly as they can and efficiently as they can within the confines of the institution without bothering the courts. Okay, so that's about all I'm going to talk about. Those are the main constitutional protections that inmates have. That's the First Amendment, the Fourth Amendment, the Eighth, and the 14th Amendment. So this week you just have to decide whether or not they have too many rights, too few. This will give you some idea. So I will go ahead and include this as part of my post to this week. All right, thanks. Bye.